We're now being joined in the studio by one of the officials of the Association of Local Governments of Nigeria to tell us why they are reacting negatively to this court judgment. So, Sogbeye Eli, tell us, what's the reaction so negatively? Why?
Thanks for having me. When you say negatively, it does suggest that we're acting in a manner that is lawless. I do not think we're acting negatively. What's happening is we're letting the world know that gradually what we have being instituted in Rivers State is some serious lawlessness and breach of the rules of judiciary and judicial practice by people who, for some reasons best known to them, think they can hide under the law and get the results they want in pursuit of political interest.
But was there a court judgment? Because based on the judgment really given by the court yesterday, there was a court judgment that ordered a maintenance of the status quo. Was there a judgment to that effect before the election?
It wasn't a judgment. By the way, at the material time the matter you're referring to was on, we were in local government chairman then and councillors per se. This was a suit that was brought by the People's Democratic Party in Rivers State, seeking to restrain the Independent National Electoral Commission from, as it were, handing over the updated voters register to the Rivers State Independent Electoral Commission to conduct the May 23rd, 2015 local government elections that brought us to office. However, it's important that we make this point clear. One, the same PDP had of its own volition opted out of the same elections, whereas over 22 parties registered under Nigerian law chose to participate in the elections. And if you ask me, the PDP alone will have the explanation to give why they opted out. But if you run your mind back to the events of March 28 and April 11, you know that somebody who conjured up extravagant figures probably will be exposed by the time we have another election in that May.
Mr.
Decided to hide.
Mr. Eli, let's clarify on what...
Secondly, what we also have here is this. The court did not order. The matter was on before a federal court in Port Harcourt. Of course, Rivers State lawyer, then Benolusa, year one for a learned advocate, had come before the court for an order of proceedings at the High Court, Federal Court that is, by going on appeal at the Court of Appeal Port Harcourt. That also had been entered, the appeal had been entered, and the matter had been reserved for October 12, 2015. It's on the strength of that notice that the High Court judge, Federal High Court judge in Port Harcourt, now adjourned sine die, pending determination of the application for stay of proceedings at the Court of Appeal. That's what happened.
So there was a ruling or an injunction that said maintain status quo. Was there one?
Injunction.
An injunction.
And it's spelled out clearly in the order issued by any judge.
Okay, so the injunction was not abided to. Instead, you went to appeal?
An injunction was spelled out in black and white in the order issued by a court under the hand of a judge.
Okay.
It was merely an advice. I'll give another scenario. Before the same Federal Court sitting before Justice Quadri, we had a situation where the Solicitor General of Rivers State argued frantically against the submission of Learned Council for local government chairman, now in the matter that we generated in the Federal Court, pursuing the preservation of our tenures, that look, parties should be restrained by an order of court, and Solicitor General vehemently opposed, and the court merely gave an advisory. That was before we got an injunction from National Industrial Court. So if the court issued a mere advisory, look, parties should not do anything to talk about the rest, that does not qualify for an injunction. It's not issued under the hand of the hand of the judge and has no seal of the court.
Mr. Eli,
so
why won't you appeal the judgment? Why are you wanting to stand by the ruling of the industrial court? Why won't you appeal this particular judgment?
Well, as far as I know, and as far as the law stands, these two courts, the National Industrial Court and the Federal High Court, Port Harcourt, are courts of equal jurisdiction one does not supersede the other. And in fact, if you want to argue further in law, they say where two equities are equal, the first in time prevails. So which injunction came first? The one they refused to obey by substituting the failed appeal to vacate issued by National Industrial Court under the horn of my Lord, the Honorable Justice J.T. Agbadu Fishing, since on the 22nd of June, or the one they issued yesterday. They chose to tamper with the judgment of, or the order of interim injunction issued under the judge sitting in the National Industrial Court in Egua. So we have, of course, as I speak to you, we have gone on appeal, and of course the law will take its course. And don't also forget, in this matter, when we came in as local government chairman, we sought to be appropriately joined when political interests had to cause RISEC to do a volte-face on preserving that which they have done, because the current political estate in Rivers State does not favor our interests. It favors the PDP interests, which voluntarily opted out. So we sought to be joined, and by the very clear wisdom of the court, that attempt to be joined was refused.
I would like to thank you for speaking with us on News Track. Mr. Eli is the chairman of the Rivers State chapter of the Association of Local Governments of Nigeria.